This courtroom hearing starts like many others, but quickly turns into a familiar showdown between the law and a self-proclaimed sovereign citizen. The defendant confidently tells the court that he does not need car insurance, registration, or even a valid driver's license because, according to him, he wasn't driving, he was traveling. He argues that his vehicle is an automobile, not a motor vehicle, and claims that traffic laws only apply to commercial activity, not private citizens exercising their constitutional right to travel. To support his position, he repeatedly references court cases and legal definitions, insisting that the state has no authority over him while he moves freely on public roads. The magistrate listens patiently as the defendant lays out his arguments, but calmly pushes back with Michigan law, explaining that an automobile is legally defined as a motor vehicle and that operating one on public roads requires registration, insurance, and compliance with state regulations. The court makes it clear that the right to travel does not mean the right to ignore traffic laws. As the hearing continues, cracks begin to show in the defendant's argument. When asked to provide proper legal citations, he struggles to explain how the cases he mentions actually apply to Michigan law. His claims slowly unravel under basic legal scrutiny. In the end, the court finds him responsible for driving with expired registration and without proof of insurance, issuing fines that total over $200. It's a calm but decisive ending to a case that perfectly highlights how sovereign citizen arguments often sound convincing, until they face the reality of the law.
Civil infraction. If you were found responsible, all other things being equal, the court would assess $125 fines, costs, and fees. It is a 0-point ticket. And in the second case that ends with the letter B, that same date, time, and place, you were issued a citation for having an expired registration plate. That is also a civil infraction. It is also a 0-point civil infraction. If you were found responsible, all other things being equal, the court would assess $110 fines, costs, and fees. So first question, is that the ticket or the two cases that you thought you were appearing about, Mr. Williams?
It is.
Okay. And same question to you, Officer Kellums?
Yes, sir.
Very good. In every civil case, the plaintiff has the burden of proof. And in a case like this, that burden of proof is called by a preponderance of evidence.
Only question I have is, will the laws of the U.S. Supreme Court be applicable? And the federal statutes and definitions of motor vehicle and automobile be applicable in this proceeding?
They are the state of Michigan laws that will be applicable.
Okay. The other question is, are you already not bound by U.S. Supreme Court rulings?
Every court is bound by relevant Supreme Court rulings.
Okay. All right.
I'm not sure why you're asking that, but that's okay. All right, Officer Kellums, if you would begin, please.
So on November 19th, 2024, I was on patrol for the Battle Creek Police Department when I observed the vehicle that Mr. Roosevelt was driving. I observed that it had expired tags on the vehicle. I then conducted a traffic stop on Fountain Street near Meacham Ave. Found Mr. Williams to be driving the vehicle, where I issued him the citations. When speaking with Mr. Williams, he could not provide insurance, and his tags were expired.
All right. Did Mr. Williams say anything to you during the stop about having insurance or not having insurance, or anything about the tags on the plates, anything like that?
He informed me that he did not have to have insurance due to that he was traveling, and to drive a vehicle, you have to have insurance. Something regarding the Supreme Court. That's about all he said.
Okay. All right. Do you want me to consider anything else at this point, Officer Kellums?
No, sir.
Okay, Mr. Williams, could you hear Officer Kellums' testimony?
Yes, I heard his testimony.
Very good. Thank you for your patience. What do I need to know, sir?
Okay, I did inform Officer Kelly that I am not operating a motor vehicle, but I am operating an automobile. I did inform Officer Kelly of the ruling of Rodriguez v. Ray Donovan, U.S. Department of Labor, 769 Federal 2nd, 1344, where the U.S. Supreme Court's decision has ruled that all codes, rules, and regulations are for government authorities only and not for human creators. In accordance with God laws, all codes, rules, and regulations are unconstitutional and lacking due process.
All right, I'm going to interrupt you just for a second. Are you telling me that a case at 769 Fed 2nd, 1344 indicates that all laws are unconstitutional?
Sir, Rodriguez v. Ray Donovan. And if
Well,
I'm not
and
mistaken,
you said that was Department of what?
U.S. Department of Labor.
Okay, U.S. Department of Labor doesn't publish decisions in the Fed 2nd. Can you tell me a little bit more about the case? What was that issue in the case?
It was regarding what we're discussing here, the requirements of a driver's license and the need when it's required to have one, stating that when you're not operating in commerce, to which I informed the officer that I am not operating in commerce as stated in USC 18 USCA 31 paragraph A6, states that a motor vehicle, the term of motor vehicle meaning every description of carriage, contrivance, propelled or drawn or mechanical powered and used for commercial purposes. This is what Title 18 USCA Section 31A6 states or defines as a motor vehicle, to which I am not operating in commerce. I'm not using
for the purposes of that particular chapter of the United States Code. It would not control what happens in terms of the Michigan legislature defining in Chapter 257 what a motor vehicle is, and an automobile
right
under Michigan law is a motor vehicle. But okay, continue.
Right, it's a motor vehicle which is described as anything, even by the Michigan compliance statute of 751, which you just stated, is determined as something that's transporting goods, which I'm not transporting goods.
I understand your position, and I can tell you that that position doesn't happen to be legally correct. But go ahead.
So you're basically stating that there's a misinterpretation of what's in black and white?
No, I'm telling you that you have misinterpreted the application of 18 USC 31A6 and 769 F second or Fed second 1344.
Okay,
but
well, I see what
I've heard your argument.
So there will be no further arguments because I see that you're not going to agree to, because like I said, I've given it to you, the cases where they're like Shapiro v. Thompson, where the U.S. Supreme Court has said that a driver license is not a requirement, that you're trying to convert a right into a privilege, to which is covered by Article 1, Section 8.
I'll ask you this. Is that right, the right to travel?
That is a right to travel, convey, however you want it, by the U.S. Constitution.
What you just told me was that somehow but regardless, am trying to convert a right into a privilege. Now, the question I have for you is, what right has been converted to a privilege?
My right to freely travel unencumbered and
now,
unfettered.
I will ask you this. How is your right to travel removed by receiving the citation?
By trying to require me to have a license to operate a automobile, which is my private vehicle.
Okay. All right. Is there anything else you want me to consider?
No, sir.
All right. Well, I can tell you this. The Michigan motor vehicle laws, including the laws that require you to carry insurance, that require your vehicle to be registered, and require that registration to be current, do not run in violation of any right to travel under the Constitution or the United States Supreme Court decision that you have cited. In fact, Michigan courts have held that essentially the right to travel means the right for you to move from A to B, not the right for you to travel from A to B under your most convenient way. So you could walk from point A to B all you wanted. You could take a taxi or an Uber or a plane or a train or a bus. But if you wish to travel by using a motor vehicle, the Michigan laws are applicable and don't unconstitutionally interfere with the right to travel. It doesn't convert the right to travel into a privilege. You are not denied the right to travel. You may be denied the privilege of traveling via a.
This courtroom hearing opens with a calm atmosphere, but it quickly becomes clear that this case is going to follow a familiar and controversial path. The defendant identifies himself as a sovereign citizen and immediately signals that he does not recognize the court's authority in the same way most defendants do. From the beginning, he makes it clear that he believes the traffic laws he's accused of violating simply do not apply to him. The core of his argument is simple, at least in his mind. He insists that he was not driving a vehicle but was instead traveling. According to him, this distinction is everything. He claims that driving is a commercial activity regulated by the state, while traveling is a natural right that exists outside government control. Because of that belief, he argues that he does not need vehicle registration, car insurance, or even a valid driver's license. He repeatedly emphasizes that his car is an automobile, not a motor vehicle, and insists that these two terms are not interchangeable. In his interpretation, a motor vehicle is something used for commerce, such as transporting goods or passengers for pay, while an automobile used for personal travel falls outside the scope of state regulation. He presents this argument with confidence, speaking as though it is settled law rather than a personal theory. As he continues, he begins citing court cases, constitutional provisions, and legal definitions that he claims support his position. He references multiple cases by name, sometimes quoting phrases out of context, other times vaguely alluding to legal principles without fully explaining how they apply. To him, these cases prove that the government has been misapplying vehicle laws for decades and that citizens have unknowingly surrendered rights they never should have given up. The magistrate listens patiently, allowing the defendant to speak at length. There are no interruptions, no raised voices, and no visible frustration at first. This patience seems to encourage the defendant, who grows more confident with each passing minute. He repeats his claims about the right to travel, stressing that requiring insurance or registration turns a natural right into a privilege, something he believes is unconstitutional. He argues that the state cannot convert a right into a licensed activity and that any attempt to do so is a form of government overreach. According to him, traffic stops, citations, and fines are all based on a misunderstanding of the law. He insists that if people understood the difference between traveling and driving, cases like his would never exist. Eventually, the magistrate begins to respond. Calmly and clearly, the court explains that under Michigan law, an automobile is explicitly defined as a motor vehicle. The distinction the defendant is trying to create simply does not exist in the statute. The law does not separate vehicles based on personal or commercial use when it comes to registration and insurance requirements. If a vehicle is operated on public roads, it falls under state regulation. The magistrate further explains that the right to travel is real, but it does not mean what the defendant claims it means. The right to travel protects a person's ability to move freely between states and within them. It does not grant permission to operate a potentially dangerous machine on public roads without following safety laws. Driving a car, regardless of the purpose, carries risks to other people, and the state has the authority to regulate those risks. As the hearing continues, the defendant attempts to push back. He insists that the magistrate is ignoring federal case law and constitutional protections. He repeats his belief that state statutes cannot override natural rights. However, when the magistrate asks him to explain how the cases he cited specifically apply to Michigan law, his argument begins to weaken. He struggles to clearly connect the cases to the charges against him. Some of the cases involve unrelated legal issues. Others come from different jurisdictions and do not apply to Michigan. In several instances, the magistrate points out that the defendant is misinterpreting the rulings entirely, taking isolated language and applying it in ways the courts never intended. Despite this, the defendant remains polite and composed. Unlike many similar cases, there is no shouting or hostility. He listens, nods, and responds respectfully, even when the magistrate directly contradicts his claims. This calm demeanor sets him apart from many sovereign citizen defendants who become confrontational when their arguments are challenged. The magistrate takes time to explain why vehicle registration and insurance exist in the first place. These requirements are not about limiting freedom, but about ensuring accountability and public safety. Registration identifies vehicles involved in accidents or crimes. Insurance ensures that victims are not left paying for damages caused by someone else's actions. Without these systems, the burden would fall unfairly on innocent people. The court makes it clear that choosing to use public roads means agreeing to follow the rules that govern them. Those rules apply equally to everyone, regardless of personal beliefs or legal theories. The magistrate emphasizes that courts operate on established law, not alternative interpretations found online or in fringe legal movements. As the discussion winds down, the magistrate reviews the actual charges. The evidence shows that the vehicle's registration was expired and that there was no valid proof of insurance at the time of the stop. These are straightforward violations under Michigan law, and no amount of philosophical argument changes those facts. The defendant makes one final attempt to restate his position, again referencing his right to travel and the distinction between driving and traveling. The magistrate acknowledges his statements but reiterates that the court is bound by the law as written, not by personal interpretations of constitutional language. Ultimately, the magistrate finds the defendant responsible for both violations. Fines are issued for the expired registration and the lack of insurance, totaling $235. The ruling is delivered calmly, without sarcasm or hostility, making it clear that the outcome is based solely on the law and the evidence presented. As the hearing concludes, it becomes evident that this case serves as another example of how sovereign citizen arguments often unfold in court. They may sound complex and convincing at first, especially to those unfamiliar with legal language, but under careful examination, they fail to align with actual statutes and case law. What stands out most about this hearing is not the outcome, but the tone. The defendant remains patient, and the magistrate remains professional throughout. There is no dramatic outburst, no sudden arrest, and no shocking twist. Instead, the case ends the way many of these cases do, with a quiet reminder that beliefs, no matter how strongly held, do not override the law.
That is what the law says, and that's what I'm finding. Is there anything else you want me to consider about that finding?
Shuttleworth v. Birmingham. US 147. Do you mind telling me what the US Supreme Court ruled in that?
US 147 doesn't give me the site of a case. That's an
Uh,
incomplete site of a case. Okay.
it was Shuttle.
And if you wish me
I
to
said
consider the case,
Shuttleworth.
why don't you tell me what was at issue in the case and what year it was decided?
I said Shuttleworth v. Birmingham, US 147, 1969, where it says
Hold
no
on. US
license.
147 is not a complete cite. The way you cite to a case is by name and then volume number and then the name of the publication and then the page number. So, for instance, when you said 769 Fed 2nd 1344, what that means is volume 769 of a book or volumes called the Federal Reporter, second edition, at page 1344. So when you're asking me about this most recent case that you've talked about, what you said was US 147, I think. That's not the citation to a case. So you're going to have to tell me more about that case. Who were the parties to that case and what issue was before the Supreme Court in that case?
Okay, so you didn't hear me cite the name of Shuttleworth v. Birmingham?
I heard you say the name. That doesn't tell me what, that's not a complete cite of the case.
All right. Do you not have the documents that I filed when I filed to say that I want to have an informal hearing? The affidavit that writes that my
there are documents that have been scanned into the court that you dropped off.
Okay. So
from those documents, why don't you tell me the proper citation for Shuttle versus Birmingham?
Okay. Traffic infractions are not crimes, blah, blah, blah. Person faced with. Okay.
Right. Traffic infractions are not crimes. That's absolutely correct. They are civil infractions for a reason.
I was reading from a different case, but the case that I'm citing from states that no license necessary to drive an automobile on public highways, streets. No license is necessary. The word operator should not include any person who solely transport his own property and who transport no persons or property for hire or
where's that citation from?
Okay, I just appeal it, and that way I can make sure all citations are.
That's fine. I mean, the idea is I can't look up what you're telling me, right, without a proper citation. So you can read. I mean, for all I know, and I don't mean this, I'm using a farcical example. For all I know, you're quoting the municipal court in Honolulu, Hawaii, which has no jurisdiction over Michigan.
It's understandable.
I don't know.
Name v. Massey, 19196 Southwest 2nd, 493, Texas, 273.
Okay. Well, and I can tell you that Texas law, a court interpreting Texas law, that decision wouldn't be controlling on a Michigan court. But that's fine. I think I understand where you're going. If you want, I don't need to consider anything else. I'm just asking you, is there anything else you want to present to me?
If you're not going to consider anything else, then we can proceed on to your ruling, of which I know you're going to find. So, and like you said, I have a right to appeal it. So
yeah, and I'm willing to listen. If you're going to quote something, I need to know what you're quoting, and I need a proper citation so I can look it up myself, right? Because otherwise people could just run around quoting Mickey Mouse if they wanted.
Is my automobile not my private personal automobile that's not being used in commerce?
I would have no idea the use of your motor vehicle, and it's not relevant to me for the purposes of deciding whether you're responsible for these civil infractions.
Okay. Well, I have nothing else for you to consider.
Well, very good. I'm letting you know the law does not make a distinction between your using the vehicle for personal reasons or you're using the vehicle for commercial reasons when your registration plate is expired and when you fail to show proof of insurance. Both of those are required.
The MCL language.
Both of those are required under Michigan law for anyone operating any motor vehicle. That's what I can tell you. So
correct. If you're a motor vehicle, to which I am not operating a motor vehicle, and this is what we are trying to circumvent.
Yeah,
I am operating my automobile, not a motor vehicle.
I can tell you that an automobile is considered a motor vehicle under the Michigan Motor Vehicle Code. So that's fine. Is there anything else you want me to consider?
Nope.
Very good. All right. So I've listened very carefully to the evidence. I do find that it's more likely than not that when you were required to by Officer Kellums at a traffic stop show proof that your vehicle was insured, that you failed to do so, and that it is more likely that your operator's, or not your operator's license, I'm sorry, the registration plates on the vehicle were expired. So I'm going to assess the $125 on the no proof of insurance case and the $110 on the expired plates case. All right. Thank you both for your time and patience. You're all set. Have a very good day.
Thank you.